Hello, I am Herb Stern, and this is the next installment of Trying Cases to Win, the Basic Building Blocks. In this installment, we are going to deal with the proper way to use two of the tools of suppleness that trial lawyers have in the courtroom. We're going to examine the use of the voir dire of witnesses, both in the presence of the jury and out of the presence of the jury. And we are also going to examine the use of the motion in limine, the tool that trial lawyers use to ask judges for preliminary rulings before their time, so that they can know how to conduct either the case, the opening, or either the direct or cross-examination. This is a part of the University of Virginia Trial Advocacy Institute's tape series, Trying Cases to Win, the Basic Building Blocks. In this one it is Trying Cases to Win, voir dire of witnesses and motions in limine. The lawyers who you are about to see are two of the finest trial lawyers in the United States, Michael Tiger of the Bar of Texas and Ben Civiletti of the Bar of Washington, D.C. and Maryland. I want to address with you now that powerful weapon, the voir dire, or as some would say in distant parts, the voir dire. In the world of the courtroom, there are very few tools of suppleness. It's a very rigid world we live in. The forms have to be preserved. Things come in their order. However, in our world, there are two tools which a trial lawyer has with some degree of suppleness. What are they? One is the motion in limine. The motion in limine is useful because it permits a trial lawyer to raise issues and things for decision out of time. The very words say it. Limine in Latin means at the threshold. Motions in limine can be used by lawyers to raise issues for decision before opening, to raise issue for decisions before direct, before cross. In other words, to get what amounts to advisory opinions from the judge, so that if it's before opening, it helps shape your case, so that if it's before direct, you know, or can find out if the judge will let you, what an adversary will be permitted to do on cross, and in this way, you know, to take steps to protect against it. Motion limine can be made by someone before doing a cross-examination. In other words, it is a tool of suppleness because it seeks guidance from the court, from the judge, before the issue naturally arises, and is helpful to a lawyer in shaping her whole case, shaping the presentation of testimony, and so forth. The second tool of great suppleness, as I have mentioned, is the voir dire examination of witnesses. Why? Because it lets you get up before your natural time. You no longer have to wait until an adversary has put in an entire direct to be able to make sounds and noises through the witness to the jury. Think about it for a moment in this way. We have discussed earlier, and say again, is the credibility of a witness as much at issue during voir dire as it is during testimony in chief? Is it? Well, think of this. Suppose a witness, which we call expert, is called to the stand, and there is testimony concerning his qualifications. And suppose further that you now do a what? Voir dire on the qualifications. True? Are you entitled to it? Yes, basically you are. You're not? Is the general credibility of the witness at issue in this moment? Yes, it is. I do not say necessarily you will do this, but I suggest to you this is the kind of messing around with the ball that we ought to be doing. Because if your answers to those questions were yes, what would prevent you, if it pleased you, to get up during the qualifications and ask that witness how many times they have testified for this particular lawyer? Or any other question concerning credibility? Yes? What is the impact of that? What is the effect of it? It means that you can poison the well before the water has flowed. Is it so? I'm giving only, as my grandmother would have said, a for instance. The use of voir dires is enormously, the potential for it is enormous because it provides us with suppleness, permitting us to do things out of natural, whatever natural is, out of the usual and ordinary time. What lawyer amongst us wouldn't love to be able to do a cross before a direct if we were the cross-examiners? Is it so? Because the order and organization of what you have to say is as powerful as what you have to say.